Okay, so we start the second panel of our conference, which is devoted to liability, and is going to be chaired by Professor and Judge Amedeo Santosuosso. Amedeo is Professor at the University of Pavia and appeal judge at the Court of Milan. So Amedeo, I give you the...
Well, thank you, Giovanni, for the invitation and for introducing the introduction to this panel. So, with this panel, we go in a field that is more specifically legal. Okay, liability. Of course, in this context, we talk about legal liability, and I'll spend just a couple of minutes for introducing the issue. There was a time when we were happy to distinguish things and agents. It was clear. Things are things, agents are agents. Okay. Now we discovered that we have things that can be agents. And the presentation by Jan was very interesting. The main and different features of this interaction between the material objects, all things, and agents. But we know that all the legislation in European countries and in Europe is based on the idea of the responsibility of the producer and the producer of things, the producer of machines. We have different kinds of legislation in this. But on one side we have agents. Okay, they are strange things. We'll say a few words about agents. But even things are not anymore inanimated things. Let's consider things in the Internet of Things. They are not autonomous, they are not agents, but they are not simply passive. Once one object has the possibility to interact with the web, is a source of information. So, and as a source of information, is not anymore passive. And on the other side, also the composition of things is another very interesting and challenging issue, because we can have things that are very complex, that are the result of the contribution of many producers. And so also the idea, okay, we save the consumer, attributing all the responsibility to the producer. But now also the concept of a producer is challenged. And when we go in the field of agents, we can discover, and we know, that we can have agents that are artificial agents that interact with the environment and with people, interact with other machines, and we don't know if they are persons or are not persons, but we have to consider that these entities have a possibility to develop their dowry of information and of concepts and of projects of action and so on. And so there is enough stuff for very good lawyers, and we have the good possibility to have as a first speaker Andrea Bertolini, that is an expert in this field in Italy, Europe, has an international experience. And Andrea, you have the floor.
Thank you very much. So I'll try to dive a bit in the details of reasoning about liability, and in particular the issue of assertment of liability and apportionment between the different subjects involved. It's not changing the slides. it's on. I can move it there. Oh, okay. It's working, it's great. Okay, thank you. So, first of all, I'll try to talk a bit very briefly, given the presentation that we already had in the previous section, whether robots are new tools or a game changer, and eventually in what perspective, whether that is an ontological perspective or rather a functional one. Then I will dive into the notion of robots as products, and therefore try to assess what happens when we attempt to apply the product liability regulation in Europe. And finally, I will come up with a proposal, which is my alternative proposal to the product liability directive, which I like to call a risk management approach. So, what is innovation? So we have at least two different kinds of innovation. We have a form of evolutionary innovation, which is just a step ahead, or a step after time. Or we may have also revolutionary innovations that are discontinuous, or at times also called disruptive. Robotics and AI are, at least in some forms, advanced robotics, probably not the Roomba vacuum cleaner, but advanced robotics and advanced AI are most likely disruptive in a way, in a technological way. However, disruptive technological innovation doesn't necessarily call for disruptive legal innovation. We may also have some innovation, but that might be to some extent incremental. What does that mean? That entails saying that even when disruptive technology is taken into account, what really matters is the impact that that technology has on our society and on our sets of values, and also on our expectations and desires as society. And therefore, if that is what matters, in some cases, innovation in the legal setting, in the legal framework, might just be incremental, not necessarily disruptive. Therefore, not everything needs to be changed. The real question is whether the legal system is fit for purpose. So, whether what we have is what we need. Now, the first question when discussing liability is whether robots and AI applications are just things, or rather, they should be considered to be agents. There is a famous article by Luciano Floridi from 2004, if I recall correctly, that says that a thermostat may be deemed an artificial moral agent. Now, I could not disagree more. And I think that the problem rests with definitions. We heard a lot of definitions about automatic and autonomous, what entails being automatic, what entails being autonomous. I think that we should further distinguish what we mean when we speak about autonomy, and when we speak about autonomy in a legal and philosophical sense. And in that respect, I really like the work of a German philosopher, Professor Gutmann from Karlsruhe, who distinguishes two notions, that of strong autonomy and that of weak autonomy. The notion of strong autonomy is that typical of a full-fledged adult human being. So the ability of setting one's goals and decide freely, so coordinate one's actions towards achieving a desired and intended outcome. So that is strong autonomy. And to make a very long story short, I don't think, and I'm quite sure about the statement that I'm about to make, that there is no current robotics or AI application that even just comes close to that. If that is true, we might say there is no strong autonomous robot or AI application. Now, if there were, that would be an agent, and an agent would bear moral and legal responsibility. Eventually, if that were the case, it would be easier to handle, because we would only have to decide whether we want to attribute rights to the robots and what kind, maybe those that were attributed in the past to slaves, or whether we want to, so providing some discrimination or not. But because we are far away from that I would like to take that off the table once and for all and say that there is no need to discuss robot rights, duties and obligation, and also liability, and we can focus on weak autonomy. Weak autonomy is the ability, is actually what we look after when we conceive robotics and AI applications. So it's the ability of the machine to perform a very complicated task, a task that is also impossible for a human being, in an efficient way, and eventually not even supervised. So that weak autonomy includes everything up to full-fledged strong autonomy. And when that is the thing we're discussing, I don't think there is any ontological ground to hold the machine liable, because the machine is not an agent. It's a very complicated black box that is performing the task that somebody else has decided it should accomplish. So this for autonomy, we could get more into the details, and I'll be happy to take questions, but just to move as fast as possible. Also, the ability to learn might be considered, but leading to unforeseeability, we heard that some machines are programmed to be unpredictable by design. And so the question is whether we may hold the machine liable because it delivers an output that its creator could not anticipate. Now, again, to make a very long story short, I don't think it's good policy making, saying that you shall make a machine that you don't understand what it is capable of doing, and if that machine causes harm to someone, you should be able to be left off the hook for the harmful consequences that the machine that you put into existence actually created. So I think that we are quite safe in making this argument that for the time being, the producer, programmer, the creator of the robot, there are different terms that are being used in the literature, might be held liable. In that, I don't see a responsibility gap. So I don't see any meaningful responsibility gap. I put a scientist up there, not an engineer, because I thought it kind of resembled one of our hosts here, Professor Miklis. Yes, supposedly that is Albert Einstein, but I don't think that he was a chemist anyway. To make a very, very, very long story short, I think that under all circumstances, for the time being, a human being is liable for accidents that involve the use of robotics and AI application. Now, the question that I'd like to ask after this one is the legal system fit for purpose? Do we have the best rules possible? And this is the kind of incremental innovation that I'm after. I'm trying to see if we can improve the legal system we have, changing it where it is necessary in order to have better incentives. So this is the idea. I don't think that robots are exceptional. This was the debate that we initiated a little bit earlier with a presentation by Ryan, and we had this conversation ongoing for quite some time, since the RoboLaw time, so since like 2013 or so. In the end, I think we agree on most things we conclude on. But the idea is that, coming from a continental lawyer's perspective, we're used to having general rules and special rules. Special rules are normally developed in order to accommodate something new that emerges, and then maybe those special rules, if they are found to be fit for purpose and working better, they might transit into general rules and become general principles of law. So, but this is a kind of incremental legal innovation. Now, this is what I try to do. So basically, identify what rules are applicable, assess the incentives they provide, and see whether we can find better rules to provide the same incentives. Now, if we exclude that robots and AI application are agents, we may safely conclude that they are indeed products, and therefore product liability rules apply. In Europe, we have the Product Liability Directive from 1985 that has currently been assessed. Last week, a very interesting study by the European Commission was released, and I will refer to that briefly in a moment. And of course, there are also standardization regulation, the CE marking mechanisms that ensures high standards of safety, investment, and product quality ex ante. So these are the two bodies of regulation that we deal with. It shall suffice to point out that if a product meets the requirements that that are applicable to it, in order to achieve the CE marking, that per se does not exclude liability. So even if a product is certified as being safe, that does not necessarily mean that the producer might not be held liable later on. So what are the main rationales and the main rules behind the Product Liability Directive and all product liability regulation is that the producer should be held liable. The directive says basically objectively liable, so there is no need to establish fault. In a more critical analysis of the Product Liability Directive, I would say it's not a truly objective standard of liability, maybe it's more a semi-objective standard of liability. And the injured party should still show that there was a causal nexus between the defect in the products and the accident that occurred, so the damage that he suffered. The rationale behind that is that we want to force producers to make products safe, and we also want to ensure victims obtain compensation. So in my analysis and my consideration of the Product Liability Directive and on Product Liability Regulation more broadly, I will try to focus on these two aspects. Do these rules make products safer, and do these rules ensure prompt compensation to the victim? So, if we try to assess product liability from a theoretical law and economics standpoint, we might say that an objective standard of liability does not force higher ex-ante investments in safety. What does that mean? Well, the alternative rule is negligence. Negligence says that you are liable if you fail to comply with a standard of conduct that is deemed demandable of you under those circumstances. Now, if under given circumstances, it is demandable of me being the producer, to achieve a certain level of product safety, holding me liable beyond that point doesn't force me to internalize, doesn't force me to make any additional investment in product safety, because simply I cannot make my product any safer than that. So this is the traditional argument that some law and economic scholar from the US like Posner and Chauvel make against an objective standard of liability as providing additional incentives in making products safe. So what is an objective standard of liability useful for? An objective standard of liability is useful to ease the position in the victim in obtaining compensation. So the objective standard of liability serves that purpose. Now the question is, does it achieve the intended outcome? Does it make it easier for the victim to obtain compensation? Now, if we consider safety, still again looking into law and economics literature, most likely safety is ensured through ex-ante standardization, and we know that Europe does that, and also through market mechanisms. Reputation does play a role. If I am in the market of making a certain product, I want my products to be of good quality, otherwise I won't sell it. And if my reputation is harmed, it will stay harmed for a long period of time. If I cheat in designing a car and I make it less safe as soon as an accident occurs, what I fear most is not a product liability claim. What I fear most is the news reaching onto the market and my sales dropping instantly. So reputation plays probably a greater role than product liability regulation in ensuring high levels of ex-ante safety investments. And when it comes to compensation, most likely, well, it is important that the victim doesn't need to show the fault of the manufacturer, but it is probably not sufficient, because the real deal is the causal nexus. So the real complex aspect is showing that the event is a consequence of, the harmful event is a consequence of the defect. Now, these theoretical considerations are also to some extent empirically grounded. There is this very interesting article published in 2012 by Helen and Tabarrok on the assessment of the effects of the GARA, General Aviation Revitalization Act. This is an act that was passed in the US in 1992, if I recall correctly, that shielded the manufacturers of small aviation planes from liability. So you couldn't sue manufacturers of small aviation planes based on product liability rules anymore. What happened is that after 20 years, they observed that the number of accidents actually decreased. So even if the product liability wasn't anymore into force for these specific sets of applications, or this, we could consider them technological products, the number of accidents actually decreased, showing that there is no correlation between those rules and ex-ante investment in safety, in product safety. So these rules do not ensure that products are made in very safe. And so again, let's now try to focus on compensation. Does product liability regulation, the product liability directive in Europe achieve adequate compensation levels for victims, or are there some problems that can be identified? And again, I would like to refer to this very comprehensive and informative study that was just released on May the 7th by the European Commission. It's the purport of a very lengthy study that was performed by the Commission itself and by external experts. You can find it online. We could discuss it at length. We don't have time to do that today. I encourage you to go and look. But a few things can be identified that are particularly meaningful. First of all, there is a limited number of cases decided according to those rules, to the product liability regulation in Europe since 2000. This number of cases has been increasing in the last 16 years, but still the number is quite limited. If you consider all European countries, there are about 700 cases that have been litigated in European courts. But if you look closer, most of these cases were decided according to other bodies of regulation. So contract law mattered more. General tort law principles played a greater role in deciding such cases. So it means that most likely consumers are not resorting to these rules in order to obtain compensation, because maybe those rules do still show some weakness in ensuring compensation to the victim. One very relevant aspect is the development risk defense, which is also one of the grounds why I say the system is semi-objective and not objective in the way it established liability. As a producer, you may not be held liable if the defect in design can be traced back to the fact that there wasn't any better knowledge, scientific or technological knowledge at the time when you designed the product and put it into circulation. This, to some extent, makes sense in a fault-based perspective, much less so if what you're trying to achieve is the compensation of the victim. Because if you're trying to ensure compensation to the victim, most likely it is the producer that is best positioned to manage that risk, to accommodate that risk. Because even if he's not responsible in the sense that you cannot reproach him or blame him for doing something wrong, most likely it's better to place that cost upon the party that is capable of internalizing it and distributing it, rather than on the single victim that suffered harm and had no involvement in it. So this is a kind of a tricky concept when it comes to ensuring compensation to the victim. And the burden of proof, again, we already anticipated, showing the causal nexus is very, very complicated. All these aspects can be discussed in further detail, but we don't have time now. So if there are questions, I'll pick them up very happily. So what happens when we have these problems? We already anticipate these problems. What can we anticipate about applying those sets of rules to robotics, advanced robots, and advanced AI? So there are at least two major issues. First of all, increased technological complexity causes the ascertainment of the causal nexus to become even more complicated. So determining whether what was the reason that led to the crash of an autonomous vehicle, whether that was the one sensor, whether it was the operating system, whether it was the malfunctioning of the infrastructure that the autonomous vehicle will be dealing with, that is going to be much more complex. So this is the issue of ascertainment. Ascertaining whether there is liability is very complicated. And even more, increased automation causes the overlapping of different sets of rules. We all speak about the moment when we'll have fully autonomous vehicles, but we tend to forget that there will be a very long transition phase where we'll have vehicles with different levels, increasing levels of automation coexisting on the roads. And that will force the coexistence and the application, the simultaneous application of negligence standards of liability and producers' liability. So objective, semi-objective, and traditional negligence standards of liability. And all these sets of rules were not originally intended to overlap. And this causes a problem of apportionment. So pinpointing which subject is truly responsible for the given accident is going to be very complicated. And we heard that before. There'll be multiple subjects involved. It won't just be the user and the producer. It will be the user, the producer, and multiple service providers. If we stick with a driverless car example, we'll have the one that is responsible for managing the infrastructure, the one that will provide internet services. So it will be a very articulated bunch of individuals that will be involved in the performance of the driving function. And then there are also some very, well, limited but relevant technical aspects of the Product Liability Directive that are problematic. For instance, it's not so clear whether software can be deemed a product. And I don't think that it would make sense to discriminate the user of non-embedded AI against the user of some form of embedded AI, so an advanced robot, in providing protection simply because when the Product Liability Directive was written, software was not so clearly included among the notion of what is a product. So how does the alternative approach that I propose differ? I like to call it a risk management approach. A risk management approach tries to place liability on the party that is best positioned to minimize costs and acquire insurance, so manage the cost, as opposed to placing the burden on the party that needs to be blamed for failing to comply with a given standard of conduct. It does so through absolute liability rules, so even more than objective rules of liability that do not allow a way out to the party that is identified as being liable, and so doesn't force to demonstrate an exact causal nexus. And the purpose of a risk management approach is to ensure prompt compensation to the victim and avoid, in most cases, if not all cases, compensation. So I cannot get into the details of this because of time constraint. I will just provide you with some examples. So again, we will stick with driverless cars. If we apply a risk management approach to driverless cars, we might say that even with a partially autonomous vehicle, because we talk about autonomous vehicle, but there are at least 5 degrees of automation when it comes to vehicles. Let's say a vehicle that ranges from 3 to 4, level 3 to 4, we might hold the producer absolutely liable. So liable for all accidents that involve the use of his car. What we expect the producer to do in such case is to acquire insurance, but not just for one car, but for all the cars that he puts into production. So that would allow some economies of scale, calculate better in a certain way what the ex-ante cost would be, and ultimately what the producer is expected to do, he would factor that cost into his production cost, and basically he would transfer the price of that insurance upon the user. Because when you buy the car, you would buy an already insured car. And that way he would distribute the cost of damages upon all users that are purchasing that technology. In that case, he could achieve compensation virtually with no litigation. And ultimately, the producer, that would be, according to a one-stop shop, the only person that the user has a claim against, the victim has a claim against, not the various service provider involved, but just the producer. He could distribute that cost along the value chain. At the end of the year, he might calculate that in 100 cases, the accident that he was held responsible for was due to the malfunctioning of a specific sensor, and he could negotiate into his contractual agreement with the manufacturer that provided him with that sensor, or he could negotiate with the internet service provider or with the infrastructure provider for a distribution of those costs. If we leave things as they are, so I wrote this quite articulated law and economics piece with a professor of economics. You will find it on SSRN starting next week, I think. If we leave things as they are today, I cannot explain the details of the maths behind that, but the idea is that before we will have increasingly autonomous vehicles on the road, we have to wait the moment until the performance of those vehicles largely, but many times, exceeds the performance of the average human driver. As opposed, if we have a risk management approach, it suffices that we reach vehicles that are as safe as the average human driver, and anything beyond that point would provide a beneficial societal outcome in terms of reduction of accidents, in terms of safer streets, and also positive economic consequences. The difference between these statuses entirely depends on the application of legal rules. So if we apply the long legal rules, we'll have to wait until driverless cars are many, many times better than the average human driver until those vehicles are diffused onto the market. That has economic consequences, that has social consequences, that hampers innovation. If we adopt a risk management approach, this will be largely simplified. Now, very briefly, one moment more. The German regulation was passed that to address driverless vehicles. Now, it's very bad to regulate technology at national level and not at EU level, but the German law is again looking for someone to blame. The grounding rationale of the German law is that we shall be, if you fail to resume control because you get distracted, then you are liable, not the manufacturer anymore. So in this case, we're again looking for someone to blame. And that will trigger a lot of litigation because it will be very hard to establish whether it was reasonable to use the autonomous function under those conditions. The UK proposal is also not compliant with the risk management approach because it requires the user to update the software of the driverless cars. Now, I think that all of you regularly forget to update the software on your personal computer. Now imagine you have to go to work, are in a rush. Would you ever update the software of your driverless cars? Most likely not. So I don't think that, even if you might be blamed for making that choice, I don't think that you are the party that is best positioned to ensure that software is updated because simply you won't update software, and we already know that. So maybe it makes much more sense to put the burden on the producer because if we made the producer liable under those circumstances, maybe he would make sure that software is updated. So very quickly, we organize a summer school in Pisa. If you're interested, ask me about it. It's funded by the European Commission under the Jean Monnet program. Thank you.
Well, thank you, Andrea. There is a question by Ryan. And
is there time for questions?
Yes, yes.
Yeah, thank you. So, thank you, Andrea. That was really very, very helpful. And as you point out, I agree with a lot of what you're saying. So, I think, though, I would like to draw your attention and everyone's attention to the fact that the analysis that you laid out conceives, it talks a lot about the standard of care that you could use, right? So you could use a negligence standard, you could use a strict liability standard. So it talks about, like, how much care does a defendant have to use before they might end up in legal hot water. You also talked about factual causation, the idea that there's a complexity. Who did this wrong, right? Is it the engineers, is it the person, and so on? And that's also elucidated by your example about shared autonomy and so on. I think what you leave out, at least from an American perspective, is the notion of proximate causation, which is where all the problems are going to be. And so if ultimately what happens here is that the kinds of harms that robots make, including cars, is not foreseeable to the individual, even though it's causally related, even though there's a strict liability standard, it's that lack of foreseeability that's going to cause problems. And so, for example, you could have a driverless car that that is a hybrid. And this driverless car not only drives safely, but it also experiments with efficiency, and it tries to figure out how am I most efficient as between gas and electric engine. Mm-hmm. And it discovers that when it starts off the day with a full battery, then it has a better day from a perspective of performance. The machine learning figures that out. One day, the family that owns this vehicle forgets to plug it into the garage, and it decides, okay, that's okay. I'm just going to turn on my gas engine and charge up my battery, which kills everybody in the building because of the carbon monoxide poisoning, because of a closed door and everything. And you go back to the engineers and you say, your car just killed people. And their response is not, there's no causal relation. Their response is not to argue over the requisite standard of care, whether it's strict or not. Their argument is, we literally did not foresee this category of harm occurring. Mm-hmm. Now, not only is that missing from the analysis, but also it makes risk management quite difficult. Because you can really only manage risks that are understood. And if the risks are catastrophic and you don't know or outside of the category, then it runs into a problem. So I guess I would encourage you to focus in like a laser on that one issue that seems to be the hardest. Mm-hmm. But otherwise, I thought it was a beautiful presentation.
Yes, it's a very interesting question. I left something out because of time constraints, but yes, you pointed exactly to, so the problem is unknown unknowns. So, but if you can split the question in different ways. So the first thing is, do you want the victim to obtain compensation? I think that my concern is, in that case, is to provide the victim with some compensation, first of all. So even in the case you made, I would hold the producer liable for that accident on purely economic grounds. And I think that even to manage the unknown unknown, the manufacturer is best positioned, because he will know, even if he doesn't know what is the unknown unknown, he'll probably be able to calculate, given the large numbers he is dealing with, that in one case out of 10,000 or even more, there will be a large problem that he did not anticipate, and he can insure against that. So he can manage the economic consequences of that, and that would not deprive the victim of compensation under those conditions. So that's why we need, I think, absolute liability rules. And of course, we have problems with unforeseeable consequences, and that is a matter of testing. So I really like that article from 2016 from the RAND Corporation that says that we cannot say that cars, autonomous vehicles are any safer than traditional ones, because in order to make that argument in a statistically significant way, we'd have to wait for 100 years. So I think that we are a bit simplistic when we say driverless cars are safer. Driverless cars will solve some problems, and they will create radically new ones, because there will be some crazy chap that one day can use his computer and cause a gigantic car crash in the city center of Florence, sitting kilometers away through his computer, most likely, if vehicles are connected. So, but again, even under those scenarios, we can, in some cases, you could also conceive some form of public intervention, but in many cases, you can manage the economic consequences by resorting to absolute liability rules and placing the burden even on parties that cannot be morally judged, and cannot even be legally blamed for having done what they did. I think that is my conclusion.
Thank you, Andrea. Now we have to move to the next presentation. Two authors, one speaker. That will be, I suppose, Palke. The title is very fascinating, because machines that are consuming consumer law. Please, you have the floor.
Thank you very much, Professor Santos. I want to ask, can you hear me well there? Is this fine? Great. This works. Okay, thank you very much. Thank you for the opportunity to speak there. This is a great honor to be able to present in this group. Today, I'll be presenting you the presentation titled Machine Consuming Consumer Law. My name is Professor Palke. I'm a research associate here at the EUI for 2 more months, when then I go across the pond, and I'll present you the thing we prepared with Professor Miklitz, but Professor Miklitz, as a good Jedi Master, judged that I'm ready as his Padawan to speak on my own. Now, this was a human judgment, not automatic judgment, so I guess under the GDPR we don't have a right to explanation. Let's hope this judgment was correct. The purpose of my talk is to present you the insights and preliminary conclusions of the ARTSI project, ARTSI being a rather loosely coined abbreviation of the title you can see on the slide, which is hosted here at the Law Department of EUI, led by Professor Miklitz, supported by Professor Sartor, and generously funded by Berkman Klein Center for Internet and Society, Harvard University, whom we would like to thank for their support, without which this work would not be possible. The general question we set up to address is, what are the challenges to the EU consumer law and consumer policy stemming from the business's use of AI? Now, given the presentations we've listened to before, I'd like to make 2 reservations here. First, I would really not like to be put into the first approach that Professor Kahlo distinguished. We're not just looking at the risks, we're also looking at the opportunities, as I hope you will see soon. Actually, I would say this distinction is not really extensive, in a sense that we are doing one thing and another. We're both looking at risks and challenges, and the question, and I agree, should be, how do we channel both in a way that is beneficial for the society? And here is my second comment. Since we are put into a session about liability, and as you will see, this presentation is not really directly about liability. I'm not sure who's going to be liable for that. The question we're asking is not as much who will be liable, in a sense, if something bad happens, who should pay the compensation. The question we have in mind is, how do we design an incentive system in a way that bad things for which someone should be held liable don't happen in the first place. And there is more to that incentive system than just liability. In other way, it's not who pays if something bad happens, what do we do so that bad things don't happen. And let me say, what do I mean by bad things? The ambition of the project is triple. On one hand, we have an empirical ambition, which is to map the actual use of the AI by the business as it is now. What are they actually doing? What are the gains and benefits to the consumers? And also map the scholarship, so what are the legal responses to that? But also methodological in a sense that, as I will point out shortly, I think there is some room for improvement in the way we as legal scholars approach questions of AI and robotics. And on top of that, normative and preparatory, the general output of the project will be the map of the uses, the challenges, as well as a list of very concrete questions that we think should be addressed in an interdisciplinary dialogue rather than at this stage a policy recommendation. In this presentation, I will quickly proceed in 5 steps. First, I'll tell you what are we responding to with this project, then I'll go through our methodological assertions, present you our analytical tools, briefly present the map of the practice, and then show example of how the output we foresee will look like. So what are we responding to? On one hand, we're responding to the business practice, which is companies are using AI currently essentially in all business sectors for a variety of reasons, and I think this crowd does not need an explanation or presentation of the fact that this is going on. And on the other hand, we are responding to a certain tendency in a legal scholarship concerned with AI and robotics, which we deem phase 1 of AI and law mainstreaming, which could be characterized by a huge excitement of legal academia, but at the same time, a little bit of confusion and initial familiarization with how the technology works. If you look at the mainstreaming of AI and law scholarship in the last 2 years, now this field is much older. Professor Sartor has been working on that since the 70s, if I'm not mistaken, but it became trendy and fashionable in the last decade, and since about 2 years, we see that more and more people are dealing with that. You can see that this is obviously a generalization, but in a lot of papers, you can see that scholars spot the AI problem, right? There is AI now, there is robotics now, and we have a problem. For example, there is a problem of liability. Who is liable? Who should be liable? Or there is a problem of black boxing. We don't really know what's happening in the machine. It's non-transparent. We need to explain it. We don't know who's accountable. Or there's a problem of data bias that leads to discrimination. And this is being deemed as the problem caused by the AI, and then we get a proposal for the solution, which is, let's make the code public so it's easier and accountable, or let's create an administrative agency that will oversee that, or grant some legal status of an agent or person, or don't grant any legal status. In general, the idea is we have to regulate, and there's like AI Act to be passed, and AI administrative agency to be set up to foresee all that. And we think that this is a necessary and important phase in the sense that lawyers do need to, since they generally lack technical knowledge, do need to familiarize themselves with these technologies. They do need to ask these questions. They do need to listen to answers to these questions and generally learn about all that. But at some point, so it's a necessary phase, but it's an insufficient phase. And at some point, we are prone to stop at the moment where we can't really move forward. And I think it's time to start moving forward now. Why is it so? And those are the methodological assertions of the project, somehow stemming from the critical analysis of the literature. We claim there will be no one-size-fits-all solution to AI or robotics, in a sense that this is not one technology, and is being used for a variety of tasks that put different legal goods at stake. And if you remind yourself the brief exchange between Professor Carroll and Professor Buta that happened after the keynote, which was, let's also look at the opportunities, right? We have judicial process where we could use machine translation. That's actually really cool. To what Professor Buta says, well, but I mean, there are big risks, right? There are autonomous weapons that can kill people. What do we do with that? We are speaking about the AI, but actually we're talking about 2 completely different things, right? First one, not being embodied with no really life at danger, where we have time if somebody thinks that something went wrong to actually stop and actually keep human in the loop. And on the other, where the legal good at stake is human life, there's no time. If we design it badly, we might have thousands of casualties. And so the legal response to one or another, and we claim there's a lot of them, will not be one response. So we argue that we should not start by bottom-up deductory approach when we say, okay, those are the rules that should guide governance of AI. We're claiming actually governance of AI is a very misleading term. We should rather start sectorally, look at very concrete problems, concrete empirical cases, what is actually going on, and what might be happening soon. to identify what are the particular risks in particular cases, and then to see what types of solutions might be best suited to respond to those risks. And these solutions might be dramatically different depending on what is the particular use. We also think that we somehow have to concretize the normative threshold in which this sort of analysis is happening. The one we are using is consumer law. This is by no means to say that this is the best or the most important or the only one. On the other hand, obviously there's a lot of considerations to be taken into account, but all these things that you can see a lot in the literature, thresholds like fairness, justice, non-discrimination, inclusion, are very important ones, but they have diverging meaning, and depending on the particular use, they might mean a different normative threshold, so this needs to be concretized. And finally, we think that there is a need for wide interdisciplinarity in responding to these challenges, in a sense that lawyers often tend to speak about their idea of AI, not really what is the AI, and that's where they would benefit from input of social scientists and engineers to understand what is actually going on. Lawyers, on the other hand, are very good at pointing out what should be the normative goals. Being normative scientists themselves, they can say, okay, we think that the society should look like this, but they're not necessarily that good at proposing the solutions, so means of realizing these goals, what you can see in scholarship a lot. Third part of the presentation, the analytical tools we use. First, what we do in the project is we study the market practice by studying numerous, basically media entries, websites, news reports, and scholarship itself. And we're trying to pin down as concretely as possible particular uses of artificial intelligence by particular businesses. And we're asking for questions in order to assess that. What is the benefit from business for using this system in a particular case? So why are they doing it? What are they optimizing for? What is for them to gain there? What is the potential benefit for consumers? Because very often there will be some benefit for consumers. Maybe products will be cheaper, maybe services will be cheaper, maybe there is faster interaction. Then what are the risks for consumers, and what are the potential third-party effects, which you know as environmental considerations, job losses, etc. Now, how do we know what is a challenge? And that's our concrete normative threshold. That's consumer law, where we basically look at what we see through two types of lenses. One is the black letter law as it stands now, where we already have established branches of unfair commercial practices, consumer rights, product safety, personal data protection. We can talk about why we think that's part of consumer law later. And then general principles of consumer law, which are the principles of weaker party protection, non-discrimination, regulated autonomy, and consumer privacy. Why? Because the particularization of consumer law, as it happened in a particular technological context, and so even though the principles remain similar or the same, the particular solutions that we might need might differ. And so, coming to the question of whether robotics or AI are exceptional, I would not say that I would say that that's not really a question we should be asking, in the sense that they might be not exceptional in the sense of ascribing liability to them as our liability regime exists. It's probably very easy to do it, as you have pointed out, and we probably can fix it, also quite without changing a paradigm. But they might be exceptional from the governance perspective, which is if our aim is to create environment in which bad things, risks do not materialize, bad things do not happen, we might be needing tools that we have not used before precisely because these risks were not happening. So to briefly tell you what is the market practice we have mapped, up till now we have covered over 200 press articles, data points across the following sectors. Those are the very different types of activities that business is using AI for, and as you see, there's a lot of types of risks that a lot of types of risks that we see from businesses using AI. What we decided to concentrate on is 4 uses for which business employs AI, which is data collection, knowledge gathering, personal advertising, automating decision making, and personal assistance. And so to show you how we foresee our output to look like, we think that these challenges give rise to 3 general types of questions. One is the normative. What should be the regulatory goal? If we sense there is some sort of problem here, what should we be actually striving at? Technical, which is if we know what the goal is, how from the engineering perspective this can be actually brought about, and political, which is how to design the incentive system in a way that will make producers, users of these systems actually make use of the technical means, which might often be costly both in the sense of lost revenues and the costs you need to put into investment. So what are the political investment, including law? That's not only law, and I think there's a bit more to incentive system than just liability. And I have 5 examples, but maybe I'll go through one in depth, given I'm probably running out of time, which is, for example, through the media practice, we see that business is using AI for personalized advertising, and we can see from different points that it happens that sometimes through personal advertising, we spot something that consumer law would label aggressive advertising, which is the advertisement uses consumers' vulnerability to make him or her take a purchasing decision. We saw an example when insomnia pills were being shown to people whose general sleep pattern was in a particular hour, and then for a few days in a row they were not asleep, and they were being shown pills from insomnia and would buy them. Now the normative question we could ask here is whether we need to, given that personal advertising now happens to be the standard, given that we cannot as easily oversee what is going on there as we could in the case of television or newspapers or traditional advertising channels, whether we need to reconsider the notion of vulnerability. Do we need more concrete cases of what are the particular types of vulnerabilities, whether we need a list of characteristics of individuals that advertisements should not be based on. And this, as you can see, are very different types of normative questions than we face when we're talking about self-driving cars and where we're talking about criminal justice system. That's the need for concretization. Then there's the technical question, which is assuming that these characteristics are part of the big data, where you can have data indirectly pointing at different characteristics. How do we actually filter that out without filtering out too much, not to decrease the benefits? And the political question, how to design an incentive system in which the producers and users of the system will actually make use of the technical solutions. We have a few more examples. Just to show you briefly, I won't be discussing them now. One more example. Okay, great. So to show you a different one, okay, there's another big thing in online ad delivery is the problem of discrimination in ad delivery. There are studies, empirical studies showing, for example, that high-paid jobs advertisements are shown just to white males, which is a huge problem. And so, again, we think that's a problem. Then there is a normative question, which is, first of all, for now, discrimination in ads is not yet illegal. Discrimination in access to goods and services is. And then the question is, in what dimensions should that be challenged, right? I mean, we can see advertisements that are based on race or gender or religion sometimes actually being fine. Say, if I'm a believer in particular religion and I'm shown a book about that, or if I am of particular race and use makeup and I'm shown makeup of that color, that's probably okay. Now the question is, what should be the threshold here, what's justified or not? And then the technical and political question are basically the same, which is how do we filter out the data that we don't want the machine to base a decision on, or do we go for output-based approach, and then how do we design incentive system in order to achieve that? There are many more questions. There were just some examples, and the bottom line claim being to move from the phase 1, we're all excited, but at the end, don't really come up with operable solutions. We need to move from these big questions to very concrete questions or very concrete legal problems and answer them in an interdisciplinary manner. So we won't go for top-down approach, but bottom-up, and maybe at some point we'll come up with a general theory for governance of artificial intelligence. Thank you very much. Full reports of our project will be available at our website, which you can see now in July. On the same time, there's yet another project we have where we're automating reading of terms of service and privacy policies. If you're interested in that, please check it out. You can shoot me an email. Thank you for your attention. If there are any comments or questions, I'll be more than happy to address them.
Well, thank you so much for your presentation, and I apologize for interrupting you, but it is, the reason is that would be nice to have some questions about this approach that is quite interesting in my view. Not the top-down approach against the top-down approach that is more intellectualistic, perhaps, more abstract. You are proposing something more concrete, more practical, and more effective. Any question? One and one. Yes, meanwhile, you go.
Yeah, so thank you. I thought it was really interesting juxtaposing these last two presentations because one of them seems to be a very pro-centralized liability model and the other one seems to be anti-liability period model. So, so the question I had for you was, is there some way of doing this bottom-up, sector-specific, empirically based analysis that doesn't automatically result in deregulation?
Thank you, that's a good question. I mean, just to say, we're not against liability. I think clearing up liability rules for each of these sectors is a necessary first step. We're just saying that probably depending on the type of technology and the legal good at stake, these rules might be different. And I don't think it's really about deregulation. I think it's more about decentralization of regulation, right? We're saying, okay, there is AI used in ad delivery, and that's maybe to be tackled by consumer law regulation, and there is ads being used in driverless cars, and that's probably someone completely different that should take care of that, no? There is AI being used in financial sector for high-speed trading, and it's probably the financial authorities overseeing this and that part of the government who is the best suited to address that challenge. So it's just to say that. Actually, you could say that if this was realized, we would result in much more regulation than less, which would be a shame. But I think that's, yes, that would be my answer.
Well, thank you.
Information coordinating position. Even if you have sector-specific approaches, you could still have some kind of decentralization in figuring out what the connections are between applications in different sectors.
Sure, that's true. Sorry, I didn't make that clear.
Maybe I think again, the major purpose is just to have a better, much better picture on where and how AI is used in this particular field where consumers are affected. Because there's a lot of talk in whatever political environment, legal, academic environment, and you have always opportunities or risks depending on the position, but a lack of serious knowledge, a lack of really what's going on. Yeah? And I think one of the purpose is really to build an observatory, yeah, and to just constantly monitor of what's going on in order not to come too easy, to jump too easily to solutions. Yeah? I think it's a modest, down-to-earth approach. Yeah?
Okay, thank you. One and one, very short.
Of Rails, Robotic and Artificial Intelligence Law Society. I'd like to ask you, do you think it's necessary maybe to change the approach? Consumer law is regulated right now, and that is a very standardized approach, so based on standardization that begins from the consumer benchmark. It goes to information requirements that are also super standardized, or the right of withdrawal, where we don't ask the question whether the consumer in question actually was in a weaker position, but we just assume that he or she has been in a weaker position. And also, of course, unfair contract terms that are also, well, the standards are also very standardized in the way that we do not ask the question so much, how about the individual contract? So my question is, isn't it that the new business models and the new possibilities business have nowadays, they can approach individually the consumer, they can assess individually the knowledge of the consumer, requires maybe a more individualized response from the consumer regulatory side.
Thank you. Maybe I say first and then. Yeah, that's a good question. And in connection with the previous question, it made me, so what we're saying is not really a method for regulating stuff here. What we're proposing is a method for researching stuff. And now how regulation will actually look like based on the knowledge we want to generate or we want to be generated, that's somehow a follow-up question to it. the approach that you mentioned might be interesting, and my answer to that would be probably, again, it really depends on what we're talking about, right? In the sense that if we're talking about, say, products, so embedded robots, say Roomba, vacuum cleaners, probably the approach we have now, which is standardized approach both to standards of production, standards of safety, and unfair contract terms, and the relation between consumer and user is fine, right? And we don't need to change that. And it might be that when it comes to aggressive advertising, say, assessing whether a particular ad was using someone's vulnerability, then yes, then we maybe need much more concrete approach. But that we can see once we actually execute the particular research question in K.
I think that's a very good question, Martin. My tentative working hypothesis is that there is a problematic alliance between the AI technology and the consumer law, which is entirely based on individual rights. Yeah? So that means, in a way, AI is just pushing the individualization of consumer law to the extreme. Yeah? You can, that provides opportunities. Yeah? In theory, you could offer better prices to the, or lower prices to the most vulnerable people, in theory. Yeah? In practice, the opposite might happen. But what is going lost, in a way, is this idea of a community. Yeah? The idea that weakness is not just something, what is an individual problem, but a structural problem. Yeah? And that affects, in a way, the consumer law itself, and that's why also we have chosen this title. Yeah? So the technology is consuming the consumer law. Yeah?
Okay, thank you. Just we have 1 minute for question and answer.
Thank you very much. From what I understand, your argument is that top-down approaches to regulation are ineffective, and that is why we should use bottom-up approaches, which are the only ones that can work, which kind of leads in the current trends of legislative inflation. To me, it seems that's the first point. But it also points out at the fact that it's very hard at this moment to find generalizable law when it comes to artificial intelligence, and to create general principles or to find general applications of principles in that domain seems hard. It seems very complicated. And I'm wondering whether this is not a problem by itself, that points that maybe law has a problem and some kind of incompatibility with AI at a deeply semantic level.
The question, please. The question. 1 minute for the question and the answer. This is a presentation.
That was my question.
What is your question, finally?
I think I got it.
Yeah, okay. Reply.
Okay, thank you for this question. One sentence answer is, yes, but it's not a problem that we can't have generalizable principles on regulation of AI, because AI is not one problem. Just like humans doing bad things is not one problem. With criminal law, civil law, administrative law for different things, and so there's no reason to have the same law for automatic weapons and personalized ads. So it's true, it's fine.
Thank you. Now, I apologize for being strict in the intervention, but I have to guarantee the possibility to the last speaker to talk about something new in this morning, that is what happens at the workplace. And I have to guarantee also lunchtime, that will be just after. Please.
Thank you, Amedeo. And first of all, let me thank the EUI also on behalf of Comau Group for this kind invitation to this panel. Today, I will show you the industry viewpoint on a very peculiar matter, which brings me back to my roots as a labor lawyer before joining the FCA group. And this is the roadmap I propose to you. Today you will hear about health and safety in the workplace and employers' liability, and how those may be affected by recent development in robotics. Then, after a brief description of collaborative robot safety, I will show you that, in fact, the safety rules and the safety specification that we have already provide guidance to new liability discourse, because, in fact, safety and liability are closely linked together. A good work on safety helps preventing liability exposure, while a good liability scheme helps incentivizing safety in the workplace. So it is advisable to look at the safety rules that we have in order to, let's say, start a good liability discourse for the future. Due to time constraints, I will limit my presentation to industrial robotics in Europe, but of course some of the suggestions discussed may be applied to other fields of robotics as well. So I think the starting point is the European Parliament resolution of February 2007 on civil law rules on robotics. In fact, this resolution shows several references to the impact of robotics in labor markets and employment, but we have seen very few comments on the impact of AI and advanced robotics on occupational safety. And this question is concerning industrial players using robotics in their manufacturing processes, because this is a new subject, and this is especially concerning Europe, where, as you can see from the chart, many European countries have a high level of robotic density. So before diving into the issue, let me summarize for the uninitiated how the current H&S liability system works. Until the 80s, let's say H&S liability rested almost entirely on member states with their own general rules imposing to employers to care about their employees. And also European member states a different legal tradition towards work compensation schemes, because I think that you know that work compensation schemes in Europe evolved on a no-fault basis, but they evolve it differently among member states. Sometimes you see schemes that are voluntary, sometimes they are compulsory, and sometimes they are structured as a state worker compensation scheme, for example, here in Italy with INAIL. So being too fragmented for a growing single market, the EU decided to step in and to establish a new protective structure, and the cornerstone was the Framework Directive of 1989, providing fundamental principles for new H&S regulations. The EU-driven system was then implemented by several individual directives describing additional H&S risks and elements to be taken into account. And at the same time, the improvement of international technical standards developed by international technical bodies such as the ISO and the ESO contributed to foster a safe approach to industrial production. Those standards are particularly important for employers because they lead to the so-called presumption of conformity. If safety standards are applied, the compliance of safety has not to be individually assessed in the workplace. And as far as H&S liability is concerned, well, the framework left the door open for member states to keep their own legal tradition. So the combination of EU H&S requirements, international standards, and national liability systems created a well-structured liability ecosystem for occupational injuries. And in this system, the employer is one of the focal points. Employers have a general duty to care about their employees, which implies several sub-duties to provide safe workplaces, adequate training, and sufficient information. And in this system, robots are nothing more than sophisticated working tools under employers' control. They, of course, need to be compliant to Machinery Directive of 2006, which is the EU General Safety Regulation for industrial machines, but they have also to be compliant to the Individual Directive on Work Equipment of 2009. And the combination of two forces the employees and employers to be compliant to some basic safety rules, like, for example, to ensure that the working tool is CE marked, to inform workers on the implementation of that tool in the workplace, and of course to provide adequate training on the use of the said tool. And what about working accidents involving working tools? Well, here you have a simple stakeholder chart. Of course, work compensation will pay at first the injured employee because, as I said, they are based on a no-fault basis. And then the work compensation scheme will be entitled to recover amounts paid in case of, under certain circumstances, for example, after a criminal sanction. But then employee may also trigger contractual liability claims under labor contracts or tort claims under the general nemilim ledere principle. And very often work compensation and employer's liability are both triggered because work compensation schemes are merely compensatory and they do not cover specific damage situation like, for example, pain and suffering. But employees have also alternative targets for their legal claims. Needless to say, the most obvious targets are manufacturers and suppliers of defective machinery. This causes the transformation of work injury claims into product liability claims, which is a common trend that is far more evident in countries such as the US. But also integrators are often called into play because most of industrial machines do not enter in the market as fully equipped instruments, but rather they qualify as partly completed machine requiring tooling integration to perform industrial applications. And this is, I would say, the chart for traumatic injuries. For occupational diseases, the situation is quite different because in order to be eligible for compensation, they need to be recognized as such, so to be put on a prescription list, which may vary from one member state to the other. So in case of unlisted diseases, tort claims may be the only viable solution. And so the introduction of robotics with advanced features such as IoT sensors, motion cameras, facial recognition, and embedded machine learning algorithms is a tremendous innovation for the field. And but these machines are designed to reach new levels of complexity, where the simple robot as a tool approach may not fit anymore. And this is particularly striking in manufacturing, where customers used to think of industrial robots as room-sized machines engineered to perform repetitive tasks behind safety cages. And thanks to physical segregation between the machine and the human operator, accident rates have always been extremely low. And accident histories shows that accidents in workplace are more likely to happen when the human operator needs to stand next to the machine or nearby, like for example during maintenance activities. Now, as the human-robot interaction increases, we have also seen that these machines are working in a more simple way, meaning that there are already on the market some plug-and-play solutions. And so more small and medium enterprises are deciding to adopt this kind of automation. And this is a concern because, as you know, SMEs represent approximately 99% of enterprises in Europe, but they rank very low on occupational safety awareness. So it's not a crime to think that accidents are more likely to happen because of this. And also, advanced robotics may have an impact on H&S system as we know it. For example, the burden of proof, or the notion of adequate training and information, or the interpretation of the reasonably practical standard in ensuring protection for the employees. So, in light of those changes, we should ask ourselves how can legislators update or fine-tune the system in order to accommodate this new robotics. And I think that collaborative robotics may be the next battlefield. In fact, cobots, as we usually name them, are lighter, easier to program, and more flexible and affordable than traditional industrial robotics. So they are perfect for SMEs looking for some smart application, Industry 4.0 ready. But the implementation of this kind of robotics is an extraordinary burden to take without proper safety instruction to follow. And here comes ISO. In 2016, ISO published the new technical specifications on collaborative robotics. Those are just technical specifications, so there is no mandatory requirement to comply with them at the moment. But they are seen as the base for incoming update of ISO industrial safety standards. Those technical specifications provide useful guidance, for example, for design, for safety requirements, and for information for use. Also providing 4 main collaborative techniques like safety-rated monitor stop and guiding, speed and separation monitoring, and power and force limiting. Also, force, speed, and pressure measurements have been taken into account, and threshold values have been tested extensively during a research project performed by University of Mainz in Germany on biomechanical limits on a true body model, which means volunteers being hit by an industrial arm until it hurts. No kidding, that was real. And well, what we can infer from the work of ISO, let's start from suggestions for regulators and legislators. The first suggestion is that a functional approach may be the best way to start talking. In fact, this finding has shown up also in other research projects, like, for example, the RoboLaw initiative. In fact, also the ISO was aware then that the collaborative robot definition was maybe a catchy move for the press, but it was truly unsatisfying. And that's because, let's say, a collaborative robot may stop being collaborative and start working the old way. Because to be collaborative means to apply the right limitation while interacting with humans. But those limitations are not irreversible, and so may be suspended if not necessary. So let's say, the collaborativeness of a robot is not an ontological feature, but rather is functional. And so to use a definition like robot performing collaborative operation is maybe a bit longer, but is a more correct definition to use while regulating such technologies. Another suggestion is to adopt a risk-based approach when we deal not with a product, but rather with a customized system. The ISO, in fact, requests a proper risk evaluation with risk description and risk mitigation plans before production. And it's worth mentioning the fact that the ISO requests the integrator to perform such risk assessment. And here again, the integrator is a functional element because it may be at times the customer of the manufacturer, the service provider of the end user, or the manufacturer, or the end user itself. But anyway, the integrator is seen as the most suited subject to deal with potential risks in the workplace. So, contrary to a pure product liability scenario, the manufacturer is no more on the front line concerning risk assessment. And, well, what about a suggestion for the employers? One could be to use risk assessment elements to ask or to provoke a distribution of liability for the overall application. Those technical specifications do not target liability because it's out of their scope, but the risk assessment may be used, in fact, for employers and for employees' representatives to get a clearer picture. So the liability distribution may be modeled on risk assessment element and may be executed through contractual agreements in order to have a clear picture of who is responsible for what. So those are the main suggestions that we can discuss so far, but The road ahead of us is full of H&S items to be further discussed. One, of course, is privacy and cybersecurity in the workplace, as cloud robotics is emerging as one of the most interesting trends for the future. Another subject is AI-powered working tools, but more generally, AI in the workplace should deserve a closer attention from public authorities in order to assess if AI exposure may qualify as occupational risk in the future. But there is one goal of major importance, which in my opinion is public acceptance of robotic tools and co-workers. This is, in my opinion, the most urgent need and yet the hardest to achieve. In conclusion, I would say that collaborative robotics may pave the way to new H&S liability system, but we need the collaboration of all industrial actors to drive the change in the safest possible way. Thank you very much.
Thank you, Corrado. Some questions, please.
You mentioned the role of integrator as made upfront nowadays for liability issues. But I see it mainly for industrial robotics and arm robotics. What do you think about service robots like humanoids, caring for an elderly, etc.? What do you think about the integrator role in this case?
No, but, well, service robots is out of my reach, but I try to make a guess. Yeah, integrators are not, let's say, are not considered that much, maybe because, let's say, a product mindset is driving, let's say, the discussion of reliability. But for example, for industrial robotics, the integrator role is fundamental. So we cannot live without them, also because under Machinery Directive, we are manufacturers of partly completed machines. So, and we don't want to enter into this realm. So it's essential for us to consider also the integration phase as a possible source for liability. But I would say the service robots may be less affected than us on that specific aspect.
Other questions? Please.
Thank you. When it comes to distribution of liability, whether it's robots in the field of consumption or in the health and safety at work field, I'm always worried that when you distribute the liability, then in theory there may be many liable. In practice, nobody is liable. Yeah. So Ulrich Beck coined this wonderful word of organized irresponsibility. Yeah. So the legal system creates a wonderful world on paper, which doesn't work in practice. Yeah. The cases, the product liability cases are full of this. So the Americans invented the market share liability. Yeah. That's one aspect. Doesn't work here, obviously. Yeah, but I think what is really needed, and it's on the discussion for decades, and I'm wondering why you don't discuss it. There must be a kind of a mandatory insurance system or a fonds system or whatever, because what happens in reality is that the only one who is liable is bankrupt. Yeah, and then the others are out of the game. So I think if you look for policy solutions, that's something to consider. To be paid for by business, for sure.
Please. Do you want to reply? No? Giovanni?
I would like to make a kind of general consideration on the basis also of the last two speeches. So it seems to me that we are sometimes thinking, we lawyers tend to think in kind of binary way. So either they are agents or they are tools, either they are learning or they are programmed. We had also this morning this kind of binary thinking that is connected to maybe also to lawyers' approach. because we have to apply or not a certain kind of norms, and we are focused on that. But on the other hand, I've seen also a kind of scalable or continuous approach. So these entities may have different level of autonomy, different capacities of learning, and we have to adopt a specific also normative solution on the basis of these different levels at which they are located. So I would like to see whether how you see this kind of, should we stick to the dichotomies, or should we have instead this kind of finer way of looking at the capacities and also classifying the consequent classifications?
Well, from my personal point of view, I would prefer to have a continuous line. I mean, just to have a continuous evolution of this liability role, and so to have not to have a strict dichotomy, because I think that this is not helping. Also, because there's let's say there's too many difference I think will spoil the way that we can advance in liability discourse.
Thank you. A bit following up on what Giovanni Sartori just asked, and also about both of the past two talks. I think that it's very difficult to talk about law considering AI and robotics, because actually no one is defining AI and robotics. And then you are making laws for something which no one knows what it is. In the field of AI, as we see it at this moment, with the big hype and the big bubble which is going around, there is everything on it, from snake oil to very complex systems and everything in between. So probably it would make more sense, instead of focusing on robots or on AI, to look at the functionalities and the properties which we want to regulate, and not so much on something which no one is defining or no one is willing to define. The same about humanoids, or about, as it goes about robots or automation in the workplace. A laptop has probably much more impact than a humanoid, and no one is looking at those issues. So probably it's more about the functionalities, about the properties, than about something which no one is willing and able to define, like AI.
I completely agree. In fact, sometimes I wonder if, and I am doubtful if AI or robotics are still two separate notions. I mean, when you heard about robot advisor, and so I start thinking about, oh, that's robotics, but not. Sometimes someone who speaks of robot advisor means some algorithms which is more AI oriented. So I think that maybe a functional, let's say, a functional way of thinking is something that could help, let's say, keep things separated and in order to, let's say, establish a good communication between speakers.
Well,
and leave it all, is AI a robot or AI, and you just leave it all open because we are not defining.
Okay. We have to close. Just one final question. Do you think that in social acceptance, emotions can play a role?
Of course.
Yes or
of
not?
Course.
Yes.
Of course they play a role, and also I think it's not even possible to teach such social acceptance. I mean, we can teach, we can raise, let's say, robotic literacy, we can raise, let's say, we can raise the knowledge of robotics basics and elements, but there will be an emotional part that I think will need many years to come up.
Well, I would like to thank the speakers and all the attendants for the participation and for tolerating such a rude chairman. Thank you.
Thanks to everybody, and in particular to the chair, in order to keep us in time. We are a bit late because of the issue we had this morning. So I give the floor now to Ula, who's going to give us some arrangements.
Yes, so the lunch for speakers is being served outside on your right, where you had your coffee break. For participants, there are sandwiches available. You go on your left, and there is a small room in there, and you can grab your sandwiches. And I would ask everybody to try to be back at 2:15.